We're going to talk about ethics and ethical dilemmas, some general ethics rules, and how they apply in bankruptcy situations. The general disclaimer is applicable here, which is I am here, we are all here as faculty for a continuing legal education program, and not particularly me in a judicial capacity. So in the words of Barbara Hauser, do not cite me to me unless it's published. That's okay. We're going to, in a moment, we've got 3 video vignettes. I want to thank the members, many of the law clerks. I can't get all the, if I tried to tell you who they were, I'd forget somebody, but they are the actors, together with some lawyers from Troutman Sanders in our vignettes. We'll do autographs after the show. And you will, on your table are some clickers. And, no, there should be some.
Yeah, lots of people have.
If you're not, see if you can find one around somewhere.
Yeah, we ran out, but we
Oh,
put
we ran
one.
out.
We ran out, but we put them in all the places where it looked like people were sitting, and I think most of you should have one.
Okay, so if you have one, you will be asked to vote on the answer to the questions posed by the vignette, and we will then discuss the answers. So, there we have it, and with that,
Sherry's going to start the first video.
where are we? We're going to start the first video. I want to thank, everybody's thanking everybody, but I helped, admittedly, but this show would not be here without Carolyn Richter. So she did, particularly this show. So thank you very much.
Thank you.
All right, Carolyn, well, I'm glad we can meet today and get everything finalized for this bankruptcy filing so we can get the company its cash to bridge the 363 sale.
You know, Mike, the DIP loan agreement says that the existing bank lender is going to get as adequate protection post-petition interest payments.
Right.
So I did a UCC search last night just to confirm the bank is perfected and entitled to adequate protection. But nothing came up under this bank's name. And I did a search under the legal name.
Well, we know they filed a UCC. We've got it right here.
Can I see that? Oh my gosh. This financing statement names the old name of the company. You know, the company changed its name about a year ago to adopt its trade name as its legal name.
Right.
I bet you the bank does not know that, because I know this bank would have amended its financing statement. The Uniform Commercial Code Article 9 is clear that once a debtor changes its name such that an existing financing statement is materially misleading, the bank's lien and collateral arising 4 months and more after the name change is not going to be covered by the financing statement. So this is an asset-based loan, right? Mostly AR and inventory are the value.
Right.
That's 8 months of inventory and AR this bank does not have a lien on.
Well, those are the main assets of the company.
Exactly.
Hello, this is Rebecca Smith.
Hey, Rebecca, it's Mike Brown, counsel for ABC Plumbing. Hey, I wanted to talk with you for a minute about the bank's lien. We did a search under the UCC records and didn't find anything the bank filed. You do know the company changed its name about a year ago, right?
No, I didn't know that. We did a forbearance agreement a while back, but they definitely didn't inform me that they changed their name.
Well, Rebecca, I hate to tell you this, but the AR and inventory of the company, I don't think the bank is going to be perfected in any of that arising over the past 8 months. There's some equipment, but that's leaned up by other lenders, and there's just, unfortunately, not much that's going to attach to the bank's blanket lien.
Oh my gosh. This is terrible. This is really bad. They had a covenant in the loan agreement. They were supposed to inform the bank if they changed their name. They never informed the bank.
Well, the bank might have a breach of contract claim, but that AR and inventory, the bank's not going to be perfected in.
Wow, this is terrible news. This is not good. Well, thanks for letting me know, Mike. I'm going to file a new UCC and a UCC amendment right now. I'm so thankful that at least we got a guarantee against the principal owner.
Hello, this is Roger Fields.
Hey Roger, it's Mike. I wanted to chat with you for a minute. There's been a significant development in the case. Turns out that there's a problem with the bank's financing statement.
I don't understand. What does that mean exactly?
Well, the short of it is the bank didn't do its diligence and get articles on the company from the Secretary of State, and its public filing is ineffective, so to speak, and the bank's not going to be secured as to most of the collateral. And based on the sell price that we've got, the bank is probably going to end up being an unsecured creditor and get 50 cents on the dollar.
You know, it really serves them right. If they just extended the forbearance another few months, I bet I could have worked my way out of this.
Well, not so fast. Remember, you've signed a guarantee to the bank.
What? Mike, we're talking about almost $1 million here. It would destroy me to have a claim like that against me personally. I mean, I want to go forward with the sale, but it sounds like if the bank's debt isn't paid first, then I'm exposed. And I don't know what assets of mine are at risk. I own most of my assets jointly with my wife, but I don't really know what that means. You know, I'm honestly not sure if we should go forward with the bankruptcy now. You're my lawyer. What do you think we should do?
Well, buddy, I think the best thing for you to do is to get your own counsel. I mean, I represent the company, and this is a clear conflict between you and the company. We've got a buyer who's ready to go, who's going to pay a fair price for the company, which is insolvent, and creditors aren't going to be paid in full, but this is a fair price, and I think that we should go ahead with the filing. And the best thing for you is to get your own counsel.
I understand what you're saying, but let me ask you this. What would happen if I delayed the sale, delayed filing the bankruptcy just for a little while to give me some time to think about this?
Well, I talk to your counsel. Let's get you lined up with someone, talk to them, but I mean, it's a short window. There's only 90 days after the bank fixes the UCC problem that it can't be avoided.
I understand. I'll get my own counsel, and I'll be sure to let you know what the company should do.
Okay, so we have some questions.
All right, we got to switch to our polling software, but this is where you all get to use the clickers and let us know what you think in response to each of 3 questions, and we're going to do all 3 polls and show you the results of each poll before we go on. So if you switch to the next slide. All right, so you know that this was counseling an insolvent company or a member of its board when there are direct conflicts between the corporation and the board member. Let's go to the first question, the next slide. Should the lawyer to the sole director and principal shareholder of the company, who's also guaranteed the debt to the bank, advise him that he would breach a duty if he delayed the filing of the bankruptcy petition to limit his own personal exposure under the guarantee? A, you've got numbers on that thing, but I think 1, 2, and 3 also say A, B, and C. So for yes, it's A, which I think is number 1. B is no, which I think is number 2. And C maybe is number 3. Go ahead and vote now. Do you see a little green light to indicate that our polling is open? It is. Okay, the polling is open. I'll give you 2 more seconds. I see a couple of people still staring at their turning point little clickers. Okay. Well, if you click on the next slide, you might have to click twice to get the results, but let's see. That's giving them 30 more seconds, so you can click again, and there are the responses. All right, 44% said yes. The lawyer should advise this sole director and principal shareholder that he would breach a duty if he delayed filing. 28% said no, and 28% in true lawyer fashion, maybe. All right, we're not going to ruin it for you yet. We've got 2 more questions, so let's go to the next question. You got those results down?
Yep.
So we can talk about them. All right, let's go to the next question. Should the lawyer advise the company that the director and officers would breach a duty if the company delayed filing the bankruptcy petition to limit the personal exposure of the guarantor? So should the lawyer tell the company that the director and officers would breach a duty if they delay filing. A, yes, B, no, C, maybe. The polls are open. I think it's going to make you do that 2 clicks between, yeah. Okay, polls are closed. Let's see the results there. 84% said yes, 7% no, and 9% maybe. Let's do the third and final question. The vignette analyzes the lawyer's duty advising directors or officers of an insolvent Georgia corporation. Is the answer different if the entity is a Georgia limited liability company? A for yes, B for no, C for maybe. The polls are open. All right, let's close the polls and see what the results are on that. No, 64%. 16% say yes, 20% say maybe. All right, I'm going to turn it back over to our moderator to discuss these hypotheticals.
Okay. We're actually going to deal with the second question, with the lawyer for the company first. And there's sort of, some of this is just sort of some reminders, but why did the company lawyer advise the principal to get separate counsel?
Well, because he has a conflict of interest, and if you look at Rule 1.7, you'll see that conflict is not waivable because the relationship here between the company and the director is that of debtor and creditor should a bankruptcy case arise. The director is a guarantor of the company's debt to the bank, to the lender, and obviously you can't represent both a debtor and a creditor in a bankruptcy case, and it's not something that you can get around by use of informed consent. Specifically, 1.7c says that client-informed consent is not permissible if the representation includes the assertion of a claim by one client against another represented by the lawyer or in the same or substantially related proceeding. So you can't represent both a debtor and a creditor in a bankruptcy proceeding. So conflict is the answer, separate entities.
The thing I would throw out here too, to be careful of, is that the lawyer and the principal shareholder, they obviously know each other. If there has been representation of him as an individual in the past, separate and apart from this bankruptcy case, you might even have a former client conflict that would mean you can't continue to represent the company in this case either. So just be careful that, depending on what the relationship has been before, if you've got confidential or protected information about this guy from having represented him individually in matters that might be related to this bankruptcy, you might be knocked out of representing either party in this subsequent proceeding under a different rule.
Represented him in the transaction, the loan transaction, original loan transaction, and the guarantee, for example.
For example.
There is also, just as a reminder, and we won't get into this, but attorney-client privilege issues are also implicated here. If the trustee is eventually appointed, the trustee will own the privilege. So any discussions that the principal and the lawyer have had while the lawyer is representing the company are going to be subject to being discovered by a trustee in a subsequent case. And then one other point that this makes is there is a duty on behalf of a lawyer representing an entity to make it clear who the lawyer represents when there could be a reasonable ground for the employee or principal to not understand who the lawyer is representing. And part of this was the principal says, well, you're my lawyer. And the lawyer properly explained that rule. Anything else on that?
Yeah, I thought he did a good job of that. I do think that people in an entity sort of assume that the lawyer is their lawyer. Anybody who represents, I represent the State Bar of Georgia, but half the time I'm doing things that some people there wouldn't want me to do. So you've just got to keep reminding people who your obligations go to, that you're not their individual lawyer. And I think the most important piece of advice he gave, and I thought he did a decent job of it every time he sort of thought about it, was you need to get your own lawyer to give you some legal advice.
All right, so the question is, should the company lawyer advise the company that a breach of duty occurs if the company delays filing? And the answers were yes, 84%, no, 7%, and 9 maybe. So, Paula, what are the ethics rules on this one?
It's Rule 1.13, which is the one that deals with representing an entity. Organization as a client is the name of the rule. And it just says you represent the entity, you don't represent any of the constituents of it, unless, you represent them sort of separately or under a different kind of an agreement. It also says that when you know that an officer, employee, or somebody associated with the organization is about to do something that could be imputed to the organization that would harm it, you have an obligation to proceed in the best interests of the organization. And this is one of the rules that was revised after Sarbanes-Oxley, because there were everybody was mad at the lawyers for not stopping corporate malfeasance, all these things that they said, well, I can't, I've got an obligation to keep my clients' secrets. And we changed the ethics rules to require that a lawyer report up within an organization anytime there's something going on by one of its constituents that could be imputed to the organization and harm it. And even ultimately, if you warn all the way up the corporate chain and can't get anybody to sort of stop whatever the bad thing is that's happening, there's an exception to the general confidentiality rule that allows you to report outside of an entity sometimes when the entity is doing something that violates the law. But right here, basically, the lawyer represents the organization, and normally he would go to this principal person to direct his actions on behalf of the organization, but if he thinks that that person's about to ask him to do something that's not in the interest of the organization, he should try to keep that from happening, basically, and disclose it to whoever there is up the chain who might be able to give him some different piece of advice.
What if he's the only one up the chain?
If he's the only one up the chain, then what the rule says is you proceed as reasonably necessary in the best interests of the organization. And so there's not a board, there's nobody who he can really go to. I think he's telling this guy, you got to get your own lawyer, and maybe that's all he can do in this situation.
This is the guy that he owned 90% of the shares, isn't that right? And then there were fractional interests, so really he could pretty much control what?
He can control what the lawyer does. And as I said, I think here, his attempts to get the guy to get his own lawyer are going to be good. But beyond that, I mean, we get into sort of a different rule that I think might come later in our conversation, but there's a separate rule that prohibits a lawyer from counseling a client in conduct that the lawyer knows is fraudulent. So he's not going to be able to tell the guy if it is, in fact, against the law or fraudulent to do so, not going to be able to tell the guy sort of how to shift liability or get out of it if doing so would mean that he's counseling the client in conduct that he knows is fraudulent. He can't really help the client, the non-client, in that way.
And this one is probably not a fraud issue.
It's not.
Here, because, but it does raise the question of, and the materials discuss this extensively, and we're going to go over, I'm going to go over it just quickly, but it implicates what the Georgia Trust Fund Doctrine. And boiled down to its essentials, the trust fund doctrine is that an officer or director of an insolvent corporation faces liability to creditors if the officer or the director prefers one creditor with the purpose or effect of benefiting the personal interests of the guarantor. It's called the trust fund doctrine. It's developed in the materials, and it's a general doctrine that applies in other jurisdictions across the country, including Delaware, which is also discussed. So, but the problem here is there is no higher authority to which this lawyer can turn. This guy is it, and there's arguably a question of what's in the best interest of the corporation. Because the corporation is insolvent, it really doesn't care. This is really a question of what benefits the general unsecured creditors versus the particular bank and or the guarantor. So the answer to the question It really is pretty clear, I think, which is that you have to go through this with the company. It could, especially if it's a company that has a board of directors that has a number of people with it. But the lawyer has to go through this and include the explanation of the Georgia Trust Fund rule. Just a quick question. This gets into 1.13B. Was that what you were talking about?
And C, though, is the one where...
B and C, yeah.
That's the one where if you really have exhausted that whole hierarchy within the organization, the rule would allow you to report out if you think that what the conduct that's happening is a violation of a legal duty to the organization. And I don't know enough about bankruptcy law to speak to whether this situation is that or not. But if it were, you could even report it. The rule just says report it to somebody who can stop it. And, you hate to see lawyers in a position where they have to report clients to law enforcement or whatever, but it might be if this is, if it was a big entity and it was a violation of some SEC regulation or something, you might have to report it there. So I don't know in this circumstance what would be appropriate, but clearly if you're getting to that point in representation, you aren't going to be representing the entity very much longer in the circumstances that we've got, where it's one guy's entity. And so withdrawal is also probably something that you need to start looking into in this circumstance.
But what about if you do it during this critical time?
If you withdraw while there is no decision being made, I'm not...
But what we had put together, though, was you basically got a 90-day preference period. So, it could be harmful.
Right.
It could be more harmful to the company to pull out.
Yeah. And then that's a problem in and of itself, because, as we talk about withdrawal from representation, one of the main things is that you've got to withdraw in a way that doesn't cause harm to the client by giving the client time to find another lawyer, for instance. And with a short time frame like this, you might be stuck. On the other hand, then, if you stay in the case, you still don't get to do something that you know is illegal just because a client has told you to. Make that clear.
It's not we forgive Paula, because
I don't know bankruptcy.
She tells us, and we appreciate her being here and putting up with all of us bankruptcy people.
But you speak a foreign language as far as I'm concerned.
We do. So this is, there's nothing illegal here, I don't think.
Okay, good.
But the question I have is, does the lawyer have to advise the unsecured creditors about this so they could file an involuntary?
Wow.
I don't know the answer.
I don't know the answer to that.
So let's go on.
I wouldn't.
Yeah, no, I don't think that, if the client is the guy
I
who's the
wouldn't.
main shareholder.
Well,
I don't
but
think there's any-
because the point is, it's the unsecured creditors who are
gonna be
being
harmed,
harmed
yeah.
by this, not the company. The company has no interest in this. It's insolvent, it's out of business, it doesn't care. Who cares? The bank cares, the guarantor cares, and the unsecured creditors care. But the company itself doesn't care. So in a sense, this points out the difficulties of working through these ethical rules to some extent in an insolvent corporation context.
Well, and based on what you just said, I would say not only should he not, I don't think he can tell anybody else with the sort of legal status of this entity in the way that you just described it.
Okay, let's turn to what the lawyer for the director should do. Clearly, he has to advise the director about the Georgia Trust Fund doctrine and the potential consequences that the delay in filing is and the potential consequence of the fact that the delay in filing is considered to be a breach of duty of the trust fund doctrine. And the vote on that was yes, 44%, no, 28%, and maybe, whatever that, 28% also. So the question is, what are the consequences of this breach of duty?
Well, one thing, a delay in filing may result in the bank getting paid, but then the director faces liability based upon the trust fund doctrine. And there's an interesting case out of the Southern District of Georgia that talks about a debtor committing fraud or defalcation while acting in a fiduciary capacity, where We had a debtor who owned two corporations, both the debtor, obviously, and the corporations wound up in Chapter 7 bankruptcy, and somewhere along the line, before the third company came in, the debtor deposited a sum of money into the account of one of the corporations after it had filed Chapter 7. The money was used to pay some debts of that corporation, but also used to pay debts of the other corporation that had not yet filed, as well as debts of the individual who owned both corporations. A creditor whose debt had been guaranteed by the debtor brought an adversary proceeding seeking to have the debt declared non-dischargeable, and the court in this case found that paying the money out to benefit her, to benefit the other corporation, as opposed to paying it all to the corporation to whom the money belonged, was a basis for denying discharge under 523A4.
So the breach of duty could be a non-dischargeable debt in a later bankruptcy case.
And that's the Farr-Luke case as cited in the materials.
And, but it might be better to have a non-dischargeable debt to creditors who might bring it as opposed to, who might not bring an action as opposed to having to owe the bank money. So that's a factor that has to be considered. And the other factor that has to be considered is, some of you may have already thought about this, but even if the company delays filing for 90 days, it is still a preference as to the director, as to the principal, because it's still a transfer for his benefit within a year of the filing, and it is still a preference for him. So if there's a company bankruptcy case, and if the unsecured creditors committee gets organized, or some major creditor looks at it, there's likely to be an action against the insider anyway. So as in many circumstances, there are no good answers for debtors in bankruptcy cases a lot, which is why the director may want to consider non-bankruptcy alternatives if they're possible, including trying to see if they can get the bank just to do a UCC sale, which creates its own problems for the purchaser, or try to do an equity receivership and do a sale free and clear through that method, or shut down and just let the bank foreclose. So those are all the alternatives that it occurs to me that the principal would have to work through. The final question is the result different for a Georgia limited liability company? And we have 16% yes, 64% no, and 20% maybe. I got to go with the maybes. This is considered at page 34 of the materials, and there's an extensive discussion of it. The short answer is this trust fund theory is an equitable doctrine. There is a Delaware case cited in the materials dealing with derivative actions by creditors of an insolvent LLC, and says under the terms of the LLC law in Delaware, only members or their assigns can bring a derivative action. So creditors can't, because that's a statute and it trumps the common law. Georgia has a similar statute. So Georgia courts, which sometimes follow Delaware, could be expected to follow that. The LLC statutes do not specifically discuss the availability of the trust fund theory, so I think it's an open question as to whether the equitable remedy of the trust fund doctrine would be a viable claim or theory when the entity is an LLC. So I think the maybes win. All right, so now we're doing vignette 2, if we can get that one ready. And in this one, the debtor and the wife jointly own a house with substantial equity. Each has substantial retirement accounts. The debtor has large credit card debts because he's out of work, and the issue is how to resolve the equitable division of property in their divorce. And we start with a meeting with the debtor's divorce lawyer.
It's good to see you again. Thanks for coming in.
You too.
I know it's been a difficult divorce, but we're ready to work on the settlement and get that finalized. So I want a good result for you, so if you have any questions or concerns, now is the time to share them.
I appreciate all the work that you've done for me, Mary, but I mean, the simple truth is that I'm swimming in credit card debt right now. The creditors are calling me nonstop. I feel like I can't escape them, so it seems like no matter what assets I get in this, it's just going to be funneled right to them anyway, so I don't know what's the point in really going through all this.
I understand. Well, you do have two main marital assets, which are the equity in your home and your retirement accounts. And the retirement accounts are ERISA qualified, so they're protected from the reach of creditors. So what we could offer is to allow your wife to have her share of the equitable division in the home equity, and then you would have the lion's share of your equitable division in the retirement accounts.
And this would solve my problem with the creditors? They wouldn't be able to go after those accounts?
That's right.
I like the way you're thinking. But if I remember correctly, when we put our money into those accounts, it was pre-income tax. We didn't pay taxes on that money. So wouldn't I still have to pay an income tax when taking it out eventually?
That's right. That's a good point. When you're 59 and a half and start taking withdrawals, you will have to pay income tax on those monies. So what we could do is we could gross up the retirement accounts to take into account the tax payments you'd be making. Now, the only problem with that would be you would be leaving your wife with very little in retirement funds of her own. So to make this more attractive to her, we might want to offer to split the gross up 50-50.
So if I understand you right, you're saying that I would get a larger portion of the retirement accounts to pay for the taxes that I would pay when I take out my share
Right.
of the accounts.
That's right.
Okay. I think that'll work. So, as you know, I really want to get this divorce done and behind me. I want to be able to move on and get all of this done with. Do you mind giving my wife's attorney a call and right now and seeing if they'll go on board with this?
Sure, no problem.
Okay. I'll step out so you can make that.
Okay. Okay, thanks. Hey, James, I have good news. I just got off the phone with your wife's attorney, and they like the proposal. They have accepted it. So all we need to do now to finalize the settlement agreement is get it in writing, get it signed, and file it with the court. Then the court will enter a final decree, and you don't have to go into court at all.
All right, and my creditors won't be able to go after any of these funds, like you said?
That's right. The retirement accounts will be out of reach of your creditors.
All right. Let's do this.
Okay.
Thank you for all your help, Mary.
Sure.
I appreciate it. Hi, Allison.
Yes, James.
Yeah, thanks for meeting with me.
Yeah, thank you for coming in. So my intake assistant got everything prepared for me, so I just wanted to go over a couple of things here. It appears you're not currently employed, is that correct?
I'm not, but I think I've got a couple good leads coming down the pipe. Got an interview coming up, so I think I could be getting a job pretty soon here.
And it seems like most of your debt is credit card debt?
Yeah, mostly credit cards.
Great. It seems like actually all your assets fall within the state and federal exemptions, and it actually seems like you have a lot of retirement income, and that can all be exempted from your creditors.
Yeah, so most of the income came from my wife's income that was put into our shared account, and then I got it in a divorce. My divorce lawyer called it a equal consolidation or a...
Oh, do you have any other ongoing litigation? I can add that to your file.
No, just the divorce, and we settled that. And I actually brought a copy of my settlement agreement and divorce decree for
Great,
you.
I'll add this to the folder and I'll review it if anything comes up about it, but I'm not really seeing any red flags here. So I think we have everything we need to move forward. The next time I'll be seeing you is the 341 meeting, and myself or one of my associates will be there with you. It's usually a non-event. It seems pretty straightforward, so I think we're good to go.
All right, I guess I'll see you at 341 meeting then.
See you then.
Thanks for taking my case.
All right, we've got questions.
The debtor and his wait a minute. Did the husband's divorce lawyer breach an ethical rule by advising him to take protected retirement assets in lieu of his share of the cash from the sale of the home? Okay, so did the husband's divorce lawyer breach an ethical rule by advising him to take protected retirement assets in lieu of his share of cash from the sale of the home? How many say yes?
I can tell you the results.
Oh, you can tell me the result?
Still working with objections.
Oh, go ahead and vote.
Use your
And she'll
clickers.
tell us the result.
No public shaming here, just vote privately and we'll tell you what the result.
Same
That's
answer,
right.
A, B, and C. Yes.
A is yes.
Yes, no, maybe.
B is no, C is maybe.
They'll start voting maybe now.
Sorry, so we're good now.
Polling's open, go ahead and vote. Vote early and often. Oh, well, this is not Chicago.
No, and I don't, the software won't let you vote more than once.
Oh,
But that's what they always say.
that's what they all say. That's what they say in Chicago, too. But you have to be alive.
Okay.
Okay, everybody's in, what are the votes?
We have 13% say yes, 85% say no, and 3% said maybe.
Okay? All right, now, so the second question is, did the husband's bankruptcy lawyer breach this is the bankruptcy lawyer, breach an ethical duty by failing to advise the husband that he might not get a discharge in his Chapter 7 case?
Polling is open.
Polling is open. Have you turned off that projector so we can show the video?
I turned off,
The next one?
restarted, but I can turn it off.
Okay. Well, we want
A
to make sure
chance
it
to cool
cools down.
We've got to see that
All
third
that hot
video.
music we had earlier, probably. Okay, polling over?
Sorry. There we go. All right, 61% said yes, 29% said no, and 11% said maybe.
Okay. All right, so Paula, what about the divorce lawyer?
Well, I think the question really hinges on whether or not what she was counseling is fraud. I mean, clearly she's trying to tell him how to avoid creditors by taking certain money instead of taking other money. And once again, I do think it's a matter of substantive law and not the ethics rules about whether or not that is fraud. But if it is, it's that same rule I talked about earlier, 1.2D, that just says a lawyer shall not counsel a client to engage in conduct that the lawyer knows is criminal or fraudulent, nor knowingly assist a client in such conduct. But you can discuss the legal consequences of proposed conduct that the client sort of comes up with. So for me, the first question is, as a matter of substantive law, is what she counseled him to do something that would be considered fraud? And as my note says here, leave that up to the bankruptcy guys. You tell me.
Well, the issue is, what's happening is, in a sense, it's a conversion of a non-exempt asset, the marital residence, into an exempt asset. So is that a fraudulent transfer? Is that fraud, Jim?
Could be, yeah.
Does that mean maybe?
If I were that lawyer, I certainly would not offer that advice, and I think people, for the most part here in this room, who do consumer debtor work have been asked that same question a lot when people come in and meet with you, or even if they're contemplating bankruptcy. That's the one thing they want to know: how can I convert non-exempt assets into exempt assets? And that always gives me pause.
Well, there's, this case actually occurred in the Ninth Circuit. There's a BAP case, it's in the materials, the Beverly case, at 374 BR 221. And what happened in a similar case, not exactly these facts, but it was a disaster for everybody because, one, the former wife gets sued for a fraudulent transfer. Because what did she get? She got an unfair share of the marital residence as an actual fraudulent transfer, because he had an actual intent to defraud, so there's no good faith defense. So the former wife gets sued and is found to have received a fraudulent transfer, and the debtor gets sued and by the creditor who objects to the discharge and wins. So before you try this at home, read the Beverly case.
Well, Judge,
Okay.
would they have a claim against either or both of those lawyers for not consulting on the bankruptcy implications of a divorce and the divorce implications of the bankruptcy? Because
Oh,
you've got the lawyer, the divorce lawyer, putting giving the final decree to the client giving the bankruptcy lawyer the final decree. It ends up in the file.
Thank you. I forgot to mention that. The clear problem here is the bankruptcy lawyer gets the divorce agreement and says, thanks for bringing that in, I'll put it in the file in case I need to read it. Obviously, you have a duty of competence to represent the lawyer. So, and to represent the client and to find out what it is about the case. So, that sort of answered the second question of did the bankruptcy lawyer breach an ethical duty by failing to advise the husband that he may not get a discharge? And the answer is yes, because one, she should have looked at it and thought about it, and two, advised him of the potential consequences. Okay, are we cool again?
We're up. Better show that third video,
Let's
huh?
go to vignette 3 while we
Yeah,
still have
'cause
time.
we are rapidly running out of time.
Gee, Patrick, I'm glad that's over with.
Yeah, I didn't expect anything like that.
Patrick, we have some serious concerns about this case. I don't know how much of this you know, but my client Herbert and Alan here were partners in a business together. My client did the client work and he was supposed to manage the financial side. They even co-guaranteed a loan with the bank to the company. But now my client has no idea where any of the money is. And he just wants to know where's the money. We haven't gotten any financial statements, we don't have any information on the accounts, but we have some strong suspicions that he has been transferring the money from those accounts to his wife, to his friends, to the rest of his family.
Herbert knows where the money went. That's why I'm in bankruptcy and he's not.
We're looking into our grounds to object to him receiving a discharge. So I'm going to need to do a Rule 2004 examination, and I'm going to have to give you a discovery request.
Let me know what documents you want to look at. I'm sure when you get them and you've had a chance to talk to Alan, you're going to discover that he didn't do anything wrong.
I don't have anything to hide.
You should expect the notice and the request by the end of the week.
Okay, well, we're going to have to get those documents together. Have you got those records, and are they organized?
I'll do my best to put it together, but I'm still going to need your help.
Okay, well, the engagement letter that we have excludes any representation for work in discovery matters unless you pay me the additional fee, because it's going to take me more time. And then it also says that it excludes any representation in an adversary proceeding, which is a lawsuit. So if they file a lawsuit like what they're talking about, I don't know that I'll be able to represent you through a full-blown trial.
Listen, I already paid you what I have to represent me in this bankruptcy. I thought I hired you to get me through this whole thing. Hi, Patrick.
Oh, hi, Alan.
How you doing?
Good.
Here's all the things I got regarding this discovery request. It's all there.
Alan, this isn't organized. This is a mess.
I did the best I could.
It's going to take me a lot of time to go through this. Remember, our engagement letter says that for discovery and other litigation, I bill on an hourly basis in addition to the fee, and the engagement letter excludes representation in a lawsuit or an adversary proceeding. So if they file a lawsuit, I don't think I'm going to be able to represent you.
You keep talking about this engagement letter. I don't know what you're talking about, but when I hired you to represent me through the whole thing.
We've got the video back, I think, for our questions. Let's see. All righty. So the first question is, did the husband's bankruptcy lawyer Breach an ethical duty, oh, wait, that's the
it.
last.
No, that's the last.
That's not this question.
We used to have one question.
Can he withdraw? Okay, should counsel, with regard to the adversary proceeding, seeking to deny a discharge or contesting the dischargeability of the guaranteed loan, A, move to withdraw, or B, represent the debtor? Anyway, even though he had not planned to do so. A or B, there is no C maybe option this time around.
Unfortunately, this is the last question.
Oh, this is the last question. All right, polling is closed. Let's see what the answers are. Wow. I like them.
All right, well, this question is really a professionalism question. It's interesting that that's the answer.
That is funny.
The ethical questions are, one, can the lawyer limit the scope of the representation? Two, can the lawyer charge extra fees for unexpected services? And three, can the lawyer withdraw without regard to whether the lawyer should or continue representing the debtor is another issue. And the fourth question is, who was that masked man? Paula, what do the rules say about limiting the scope of representation?
They allow it. It's actually Rule 1.2. I'm not. It's called Scope of Representation and Allocation of Authority between Lawyer and Client, and it says that if the lawyer gives you the client gives you informed consent, that it's okay to limit the scope and objectives of representation. There are a couple of caveats to it, though. One is that the limitation must be reasonable under the circumstances. And the second, as I mentioned, is that requirement of informed consent. The client needs to understand what it is that he is agreeing to and give some sort of voluntary agreement. And I had my doubts about the guy in this vignette, frankly, is whether he got it, that when he entered that initial agreement, that meant the lawyer wasn't going to be there with him if things got complicated, frankly. So this rule actually is relatively new for Georgia. I think it came into being in 2000, 2001, something like that. And we still have judges who hate it because, particularly in the domestic, well, in this case, for instance, what this may result in is as soon as it gets to the point where you're standing before a judge, this guy might be unrepresented. And so a lot of judges don't like the rule, but what we found is just until people can afford lawyers for whole cases, this might be the best that we can do under some circumstances.
This is the bundling, unbundling controversy that is currently a fairly hot topic in the bankruptcy world and possibly in the consumer world generally.
Domestic too, yeah.
And domestic. In the consumer bankruptcy context, there is a case that I decided is called Egwin. It's cited at page 48, and it follows basically what Paula just said, which is, in a consumer bankruptcy context, given the objective of the representation, which is to discharge debts and keep property, it is probably not possible for a consumer client to give informed consent, or for the lawyer to exclude that type of representation in view of the objective. That does not mean that he has to do it for free, but it means it can't limit the scope of the representation. The Northern District of Georgia Local Rule 9010-5A at page 47 adopts this approach. It says if you represent the debtor in a case, you represent them in everything, including motions and adversary proceedings. What are the other rules are? Middle?
Well, let me look. The middle says that you're basically in until Judge Laney says you're out. And that is Local Rule 9007-1. It says the court will consider excusing the attorney from further representation for cause shown.
And what about the Southern?
Not quite so clear. In the Southern District, if you look to withdraw, you need to look at the District Court Rule 83.7, which is entitled Withdrawal as attorney of record, and it sets out the procedure there that I think would be certainly recognized by the bankruptcy judges and be appropriate way of seeking to get out of a case. But you won't find it in the bankruptcy rules. Look in the district court rules, and as best I can determine, I don't know that there's a unified opinion among our 4 judges. It may
Could
have
you give them the
with
clickers, and we'll let them vote?
It may have to do with the engagement letter, and if you all are not doing engagement letters, you really should for a variety of reasons, not the least of which is, if you are a debtor relief agency, you're supposed to be doing that in all cases.
Which you are.
Which you are.
Judge Davis's contrary opinion has been overruled.
Well, do you have to do 2 engagement letters, though? Is one to begin with, and then if things turn out differently, like on the adversary or the objection to discharge or something, do you have to do another one?
Well, you may, and that brings to mind the Rule 2016 form that, again, all the debtor lawyers know what I'm talking about, and probably the creditor bar does as well, which often just gets filled out without anybody giving any thought to it. How much did you get paid up front? Who paid you? What's the balance that you owed? And it has 4 or 5 subcategories down there of things that you will do. And in my practice as a Chapter 7 trustee, I look at those as a part of prepping for 341 meetings just to see who's getting paid what. And it's amazing to me how little editing takes place on those Rule 2016 statements. So as a result, if you don't change anything, you're probably in for the case.
And maybe for the flat fee.
Yes, and for a flat fee. And for a flat fee, if you take $3,000 and you don't say this excludes an adversary proceeding, or if an adversary proceeding is filed, an additional fee agreement will need to be entered into, something.
But you know what difference does it make, though, buddy, when you think about it? If they don't have any money, like the guy says, look, I paid you everything I've got.
Yeah.
You know, that's all I've got. That's all I'm going to have. I'm bankrupt. You know, what do you want me to do? You're a rich lawyer.
Just do it for free.
Just do it.
Do it for free.
Well, for sure, you're in the case until your judge enters an order that says you're out. So be very mindful of that you are in the case until the court enters an order once you've complied with the appropriate rule of your district to let you out of the case.
And let me just say, we've had cases, not in the bankruptcy context, but we have had disciplinary cases involving bad attempts to limit the scope of representation. So for the disciplinary board, what's important is how foreseeable it is that more work is going to be required, and that it's going to be required in a way that's going to sort of harm the client to have a lawyer getting out at that point. So we've seen cases where a lawyer takes a case fully intending to settle a personal injury matter and says, I'm going to take it for purposes of settlement, not going to go to trial, but then it gets put on a trial calendar and the lawyer doesn't get out, sort of thinking that's going to pressure the client into settling up to the very last minute, and then wants to leave the client in the lurch by attempting to withdraw, essentially, literally, in the case where we have discipline, on the day of trial, telling the judge, here's my written agreement, the client agreed to this, I'm not supposed to have to try this case. Not surprisingly to me, the judge said, we're about to start a trial and I'm not letting you out. And so he was completely unprepared for trial. So you've got to, I think this whole concept really depends on there being these finite points in representation where you can handle matters like this in a way that's reasonable, and a lot of times it's just not reasonable.
I think it would be fair to say, first of all, the second question was, can the lawyer charge extra fees? And I think the answer to that is yes, you can do that, depending on what the engagement letter says. And then, can the lawyer withdraw? And I think the local rules that I talked about in the Egwin case that I decided does not say you can't withdraw. So, I think inability of a client to pay fees is a ground for withdrawal. And so then the question becomes, how do you do it? and the rules say you have to do it in a way that does not adversely prejudice your client, or something
Yeah.
to that effect.
Right,
And
Mark.
so, to me, what that means is, if you're not going to do the professional thing and hang in there and help this poor guy, what you've got to do is sit down with the client and explain what the lawsuit is about, what's going to happen, what the discovery is likely to be, what his obligations are going to be, what the law is, what the standards for the other side to win are, and at least give the debtor some information that will give him a fighting chance.
We have a question in that.
Question?
Just a comment, wasn't there a case a few years back by one of our judges about how you really have to keep it out of these financial files?
Wait a minute, I can't hear the question.
Can't let the debtor go into default before you get out?
Yes, that's the Egwin case, yes. The question is, isn't there a case that says, when an adversary proceeding is filed, that you cannot let the debtor go into default? And the answer, that is the Egwin case, and the answer is yes. Fortunately for the lawyer in that case, it was, there was no default, there was no harm, no foul, but because the client actually entered an appearance. But in any event, I think you have to do something to try to give the debtor a fighting chance, and if you need to get more time to withdraw, you got to file a motion to extend the time to answer.
And,
Or you got to answer.
one practical thing to think about, too, is, the harm that you're going to do to the client, the attorney-client relationship. And is it easier just to go ahead and finish this case and take your hit, maintain a good relationship with your client?
And the judge.
And the judge, and opposing counsel, and just every once in a while, you're just going to take a hit on these cases. I mean, we just do that. And I'm thinking the answer is probably yes. You should just go ahead and do it. There's, not every time, but but sometimes.
Paula, we were going to give Paula 10 minutes to talk about LinkedIn.
LinkedIn, a total change of subject.
We now have 3.
We have 3 minutes, and so what I'll do, Carolyn has done a great job in the materials for this segment, summarizing the sort of shaky state of the rules with things like LinkedIn and online profiles, and she wanted me to talk about that for a little bit. Let me just say that the bottom line is you need to be aware that all that online content about you might be considered advertising by the regulatory authorities, by the bar. And it depends. I think the hard part about things like Avo and LinkedIn for lawyers is that some of the content isn't even put there by the lawyer, and yet the lawyer might be responsible for it. And there's a New York opinion that's cited in the materials that finds, in fact, that a lawyer has an affirmative obligation to go out and check what's out there in cyberspace about him or her, and to try to correct things that are out there that are false, even if the lawyer isn't responsible for putting them there. So we haven't got a similar opinion. We don't have any guidance on it at all, really, in Georgia, and we use just the regular advertising rules to govern that sort of thing. It's hard for me to say that I could hold you responsible as a matter of ethics for something that you aren't responsible for having put out there. But I guess, the bottom line from this New York opinion is that if it comes to your attention that there is content on one of those kinds of sites that isn't true, no matter where it came from, that you have an obligation to try to correct it. And of course, that's more than a notion in and of itself. So be aware that to the extent that you're trying to get business from any of those sites, LinkedIn, Avo, I'm trying to think of the names of the other ones, that we might consider that they are advertising within the meaning of the rules, and that you need to comply with the advertising rules as a result.
Thank you all for coming. Thank you all for being lawyers and helping the courts. And Claire, do you have some closing, or are we just done? Okay. Some people I think might have had questions. We'll be here after the program if you want us to answer them.